So I'll be discussing the rise of non-standard employment, particularly in Southeast Asia, my region, ASEAN, but also including other Asian countries as I go on with my presentation. And of course, the changes that have taken place as a response to the rise of non-standard employment, even in other parts of the world. And of course, what have been the trade union responses and strategies that address non-standard employment. But first, let's start with some concepts. Okay, my outline first, there will be two parts. The first part would be, I will discuss the concept and characteristics of non-standard employment. What is this kind of animal? The trends in non-standard employment or NSE in selected ASEAN and other Asian countries, the changes in regulatory frameworks on non-standard employment, my proposed typology of regulatory,
Sorry, I'm super sorry.
of regulatory framework. So I came up with a typology which can also be applied in other countries outside Asia. And then conclusion for part one. And then we can have Q&A. And then we proceed to part two. What are the trade union responses so far to, and strategies on non-standard employment, and then conclusion. And then if we still have a bit of time, we can do a small exercise or group work. But I don't think we can do that because of, but anyway, let's see. So I start with the definition of non-standard employment. So if you can see in your slide. So of course it's the opposite of standard employment. You know, the concept of standard employment in the 40s mode of production, for example. I think you have discussed this one in your previous sessions. So when we talk about non-standard employment or NSE, we're talking about fixed term or short-term employment. It is not full-time. It does not involve, okay, it can involve, but some does not involve a direct, bilateral, and subordinate employment relationship. It is often outside the coverage of labor laws, or if ever it is covered, it's limited coverage. It is less regulated compared to standard forms of employment. And in some forms of non-standard employment, it involves work in multiple work sites. So you go from one work site to another in the lifetime or duration of your employment engagement. If there is an employment relationship involved, because there can be an employment relationship or no employment relationship at all, as we will discuss later on. So the ILO, because there are many concepts of non-standard employment. In fact, in many countries in Asia, the term non-standard employment is not used. It could be non-regular employment or non-permanent employment. But the ILO came up with 4 categories of non-standard employment in their 2016 publication on non-standard employment around the world. So they proposed 4 types. First type is all forms of temporary employment. It's not open-ended. As you can see, it's short-term duration. Already at the time of engagement, you know when it would end. Your work would end, no? So this may include fixed-term. This may include fixed-term contracts, including project employees, for example, or project workers, project-based, for example, in construction, or task-based contracts. For example, you're a daily casual worker, seasonal work, casual work, and of course, including daily work. The other category is called part-time and on-call work. And this is, of course, not full-time. You have normal working hours, but it's fewer than full-time equivalents. So it also includes marginal part-time employment. What does that mean? It's a kind of employment where it's short duration, where you just work for different countries. There are diverse part-time employment duration, but marginal would mean you working less than 15 hours or 20 hours per week. And of course, on-call work, every time you're on call, and which includes 0 hours contracts, like what is very, very much prevalent in the United Kingdom, in the UK. The third type would be the multi-party employment relationship. meaning it's not just a direct employer and a direct employee or worker. This is sometimes called dispatch work or agency work. There is a triangular employment relationship. And this is very much, are you from South Korea?
Yes.
Yes.
Yeah.
In-house subcontracting, for example, which is very prevalent in manufacturing, shipping in South Korea. This agency work or dispatch work or outsourced labor. So these are the forms of multi-party employment relationship, subcontracted labor. So different terms for different countries. There is no single set of terms of multi-party employment relationship. There's no universal term, no, for all countries, not just in Asia but in other countries as well. And the fourth category would be disguised employment or dependent self-employment. So this is not part of an employment relationship. There is no employment relationship involved between the worker who directly performs the work, and the organization or the company that utilizes the work of the employee. So this is like, for example, in the independent contracting, but disguised or bogus self-employment, they call that. So these are the four categories of non-standard employment as proposed by the ILO. Now, you would ask, so what about the characteristics of non-standard employment? As you can see in this figure, this is again from the ILO, they came up with this figure in terms of the intersection, or the overlaps of various forms of non-standard employment with informal employment and precarity or precarious work. So you can see here. So you have here the orange thing. These are the different categories of non-standard employment, and the yellow shaded area there it's called informal, meaning you don't have an employment contract. That is the principal characteristic of that. And of course, precarious work. I mean, you know what precarious work is, and we can discuss that later on. So you can see here, for example, most of these categories of non-standard employment are intersecting, with informal employment. And of course, also, many of them have also intersections with precarity or precarious work. That's why in some countries they call, for example, in the Philippines, they call the forms of non-standard employment precarious employment or precarious work. Also, I think in South Korea, so in many Asian countries, in ASEAN, for example. So, yeah, those are the characteristics. As you can see here, we summarize the characteristics. Of course, non-standard employment is, in short, associated with precarious work. What do we mean by that? There are many risks and insecurities involved for workers on non-standard employment. They are more likely to transit or to transfer or shift between non-standard employment and unemployment. And the unemployment spell is longer for non-standard workers. That's why they experience substantial wage penalties or wage reductions because of fixed-term contracts and short or long spells of unemployment. Of course, they experience erratic working hours, meaning non-regular hours. Of course, also exposed to occupational safety and health risks. And because many of them are outside the employment relationship, there are gaps in Social Security coverage, principally because they can be covered, but they have also to shoulder the employer counterpart of the Social Security premium or contribution. And for many non-standard workers, they simply cannot afford that. That's why many are outside the coverage of formal Social Security systems in their respective countries. Many non-standard workers also lack or have limited access for training, because why would the employer or the company invest in training you if after 1 year or 2 years, you will leave or you transfer to another employer or your contract terminates? And then, of course, And the most important feature of precarity for non-standard workers would be they lack access to representation, meaning it's very difficult for them to organize into a union or any other forms of workers' organization or workers' association, so they may not effectively exercise their fundamental rights at work, including the right to bargain collectively, because of course, it's difficult for them to organize into a union, but later on you would know that they can, very innovative ways. So in short, non-standard workers are more likely to suffer well-being penalties because of the characteristics that we have just mentioned earlier. And of course, because of that, they are lower job satisfaction as a result of job insecurity. Short-term contracts, for example.
I'm sorry, Melisa.
Hello.
Would you please mute yourselves? It's very disruptive to hold a presentation when there is a microphone on in the audience, okay? Thank you.
Okay. So now let's see the trends. So here you would see selected ASEAN countries. And are there people here from Indonesia? So I have here Indonesia, Philippines, Singapore, and Vietnam. So as you can see, the orange, I'll just look at here. This is comparing, as you can see, these are different periods because different statistical systems and non-regular, non-standard workers often are missing in the statistical systems of many countries. Often it's not regularly captured or it's just periodic, like every 3 years, every 2 years, but not the regular, for example, labor force surveys. No. Although now some countries are doing it, including it in the labor force survey. So in various years, you can see here the increase in non-standard employment, for example, in Indonesia between 2001 and 2015. So 2001 would be the blue bar, the orange bar would be 2015. There was also an increase in the Philippines, nearly 1 in 3. In Singapore, it's only in Singapore where you have, a lower incidence between 2006 and 2016. And of course in Vietnam as well, it is over 1 in 4. These are all the temporary employment contracts that we have, I have shown you earlier. So at least in 3 countries, amongst the 4 countries, you see here an increase in the incidence of temporary employment as a form of non-standard employment in these 4 ASEAN countries. Here again, I would show the proportion of temporary workers or temporary incidence of temporary employment in selected ASEAN countries. This one. So here I included Cambodia, Indonesia, Pakistan, which is not part of ASEAN, but it's included here, and Philippines and Vietnam as well. So you can see here, except in the case of, what is this one? Indonesia and the Philippines, you have temporary workers having, a bigger share of wage workers. In Cambodia, over half of wage workers are temporary workers. In Pakistan, it's staggering, nearly 3/4, 3 in 4. And in Vietnam as well, it's more than half, So you can see how big the incidence, in terms of, the share of temporary workers of all wage workers, those who are receiving wages and salaries in the country. Women. So what about women? So in most countries, in terms of temporary employment, female workers, of course, are overrepresented in temporary employment relative to males, particularly in the services sector. And here you can see I've included here Bangladesh, of course, which is not part of ASEAN, but it's part of Asia, you all know that. Myanmar is part of ASEAN. Nepal is not part of ASEAN. They're South Asians, Sri Lanka, and China. So you can see, very, very big proportion or share of women in temporary employment, the second column, no? And then among men in compared to among men in temporary employment. So you can see, in the case, in all the countries involved, no, the share of women in temporary employment, no, far, exceeds men in temporary employment as well. So there is an overrepresentation of women in temporary employment, and in fact in many forms of non-standard employment, particularly in the services sector. Again here, this shows you, again, in other ASEAN countries in terms of age. What can you say about the graph? What does the graph show you? So we have the left, the most orange would be the 15 to 24. The second bar would be 25 to 54, and the third bar would be 55 to 64. So what observations can you make? Yes, please.
The younger workers are most in the temporary employment.
Where?
In that first thing, it's Vietnam. Yeah.
Only Vietnam?
Philippines and Pakistan.
Philippines and Pakistan, yeah?
Yeah, but it's interesting that Indonesia is it's actually the opposite of Cambodia, for example. Like, I mean, not proportionally, but it's different.
Yeah.
From one country to another.
Yes, but they're the same. In Cambodia and Indonesia, the 55 to 64 age group, they have more representation, they are more wage employees, no, on temporary as a percentage of wage employees. So you can see some differentiations and similarities as well. Yes, please.
We can know why in Vietnam the youngers are so exposed.
They're so exposed to
the temporary
wage employees.
Yes.
Because of course, in manufacturing sector in Vietnam, there are many young workers. And non-standard forms of employment are very, very much prevalent in Vietnam. So that is why you have like a bigger proportion, no, of 80%, no, of all workers, of all wage employees having a big proportion in terms of their wage distribution amongst the temporary workers.
So can we directly connect it to the size of the manufacturing sector?
Yes, it can be the manufacturing sector because non-standard employment in many countries is prevalent in the manufacturing sector, in the services sector. I mean, there are many forms of services sector, right? You have.
It represents basically half more, 100% more than the other ages, right?
Yes.
It's a lot.
Yeah, it's a lot. It's really a lot. It's very substantial. It's staggering. Yeah, but nonetheless, a non-standard employment cuts across sectors. It cuts across sectors, So, and it depends on which sector is, for example, prevalent in terms of employment generation in each country. For example, in South Korea, it's very prevalent in manufacturing sector. The in-house subcontracting, for example. And there you can see, I think in South Korea, the latest statistics is more than half, 52% of all wage workers, is correct, are in various forms of non-standard employment, and that is big. And many are in the manufacturing sector, because that's the base of South Korean economy. In the Philippines, it is in the services sector, because that is the biggest employer or employment generator in the Philippines. So it depends. In Cambodia as well, and in Indonesia, So in Indonesia, for example, in the electronic sector, it's very big. Okay. So we can have the questions later on. I just want to hear your voices. I'm bored of my voice. Here again, a part-time work. Now here, part-time work is defined as less than 35 hours per week. And this is 2014 data from the ILO. So here it's about, again, the proportion of women and men in part-time work, you know, and then we saw here, for example, what country is this? This is India, no? So India. So you can see there the shaded symbols. What is that? So the red would be 40+%. The next darker shade would be 30 to 40%. Then the orange one would be 10 to 20%. The darker peach color would be 10 to 20%. And then the peach, so that peach, 0 to 10%. No? So what are your observations on this figure, or how do you call this one? Picture or what?
Pictogram?
A pictogram, yeah.
Sure.
Yeah. So that is India, and I think, yeah, the long one would be Pakistan.
Yes, that's what's it.
Yeah. And then down there is Bangladesh. Then the Philippines is the one separate here. And then below would be Indonesia, the one there. Yeah, so what could be some of your observations, you know, between women and men in part-time work?
We work more.
In part-time. But there are more women, you know, in part-time work. Where?
India?
In India, it's very visible.
Uh-huh.
It's a paid domestic work.
Yes, yeah, correct, yes. Paid domestic work.
Which
no?
is like done more by women in India than men. So that could
Okay.
be one of the factors that's increasing that percentage, and also manufacturing.
Yeah,
The women work part-time.
and construction, brick and kiln making,
Yes.
yeah. Then, what else? That one is Japan, up there. And what could be the reason, no? There are many reasons why women, you know, choose, or sometimes it's not a matter of choice, it's the only job available, right?
Because they have to take care of the family too.
Yeah, yeah.
Working and family.
And paid care work. Yeah, okay, yeah, correct. So there are many reasons, no? It could be by choice or no choice at all, right? Also, I think in South Korea, what are the other countries represented here from Asia? Yeah, no? You're from?
From Belarus.
Belarus, okay. We can share later on, you know, the experiences. So here again, you can see, you know, women being overrepresented in part-time work, which is a form of non-standard employment, whether by choice or, you know, they have no other means. They have no other choice. No? Okay, we can discuss later on that one. Look here. So we go to the regulatory gaps. You know, I mean, of course, non-standard employment in many countries. There are gaps in terms of regulating these forms of employment. And these are the areas where there are gaps in terms of laws, regulations, policies, whatever you call them, no? Whether at the national level in country, or at the regional level if you have regions in the country, and even at the workplace level through collective bargaining and other or company policies. So we have here in the areas of employment security, in terms of income stability or earning stability or security, in terms of working hours, in terms of OSH, occupational safety and health, in terms of social security coverage, access to training, and of course access to collective representation and the right to bargain collectively. And I will go through this one by one. First is what has been in general the response of governments in terms of the rise. You see how prevalent it is, no? Very high incidence in many countries in Asia about various forms of non-standard employment. So the response of many countries has been tightening the regulations. It's regulatory tightening, or trying to plug the holes or the gaps in terms of regulating the following areas. So the regulations have something to do with equality of treatment legislations. No? So non-discrimination in terms of at least wages, no, and job security opportunities for between non-standard workers, all forms, some forms of non-standard workers, and workers on permanent. Let's say non-permanent workers and permanent workers, and I will show you some examples later on. There are also regulations in terms of setting minimum hours, no, and safeguards for workers on part-time, on-call, and casual work arrangements. Of course, the issue of employment misclassification, which is often addressed by case law. I think in South Korea there are many case law. In Indonesia, they have provided, a list of jobs that cannot be subcontracted, for example. So many, and then trying to establish, that an employment relationship exists. And I will tell you why this is important. And this is also an issue in the gig economy, in the platform economy, which I consider as a form of non-standard employment. It's not employment, but it is a form of non-standard work. And of course, another would be restricting the use of non-standard employment, meaning some trade unions, I will discuss later, were able to, through collective bargaining, were able to negotiate with their employers that these jobs cannot be outsourced and only workers on permanent contracts can do these jobs. And of course, or you can only be on a non-permanent contract for 2 years. If you exceed the 2 years, that contract starts to be permanent. Or they say that this job is a permanent job, can only be occupied by permanent workers. That is what happened in the regulation in Japan when they amended, their labor laws. And of course, the last one would be assigning liability. So if, for example, if I am an agency, employment agency, and then there is a principal, you can't see? Okay. I will share my slides to you, no problem. And there are even notes in my slides. So assigning obligations and liabilities in contractual arrangements. For example, in agency work, if the agency, for example, that hired you as a dispatch worker fails to pay your wages and other benefits, then the principal or the company for which you directly perform work is liable to pay, your wages and other benefits. So that's what it means in terms of providing also these regulations. So it's important, for many non-standard workers, particularly those on multi-party employment relationship and the other category of independent or bogus self-employment or dependent self-employment, to show that there is an employment relationship, because if they can prove that they are in an employment relationship, they are covered by labor laws in many countries. So, meaning they are entitled to workers' rights and labor standards as provided in their labor laws and other social legislations. As you can see here, if you are in an employment relationship, at least you have employment and income security, but of course nowadays that is not a guarantee. And we can debate about that later on. More likely, you have safe and healthy workplaces, Okay, you can participate in enhancing productivity of your company, and you get incentives for contributing to that. Of course, stable economy would be the macroeconomic impact of having more permanent jobs for workers. Voice, representation, collectively, fair treatment, equality of access in terms of training, promotion, etc., and of course, social protection. So all these, all the elements in that circle entitle workers if they are in an employment relationship. So here are now the changes in the regulatory frameworks per country. So on the first column, you see the regulatory responses of specific regulatory responses, and the second column would be the countries that have adopted these regulations in terms of policies, laws, sometimes administrative orders or department orders or ministerial orders, or in Cambodia they call it prakas, so issued by the Ministry of Employment or Department of Labor or whatever, no? Ministry of Manpower. So for example, there is a legislation on equality of treatment between standard and non-standard workers, often as amendments introduced to existing labor laws in this country. So you have here in India, but I have here only for agency workers, in Japan, in Thailand, South Korea, Vietnam. So we don't have time to, but I can share with you my other slides that detail these legislations. In the Philippines and Singapore, most often through case law, meaning like the decisions of the Supreme Court, for example, no? Or the Supreme Court. So in terms of establishing the existence of unemployment relationship, and then assigning obligations and liabilities in multi-party contractual arrangements, between, of course, the dispatch company or the agency, and of course the principal or the user company. So we see these forms of regulations existing in Japan, the Philippines, Singapore, South Korea, Thailand, and Vietnam. So in many countries in Asia. Oh, it doesn't. Yeah. So again, there is also legislation or regulations on the prohibition of using fixed-term work for permanent needs of the enterprises. I mean, what is necessary and desirable, they say that. Those are the clauses there, no? And this we found in India, particularly in the but the IT and BPO industries are exempted, and also, but there are exemptions in some countries. No? Export processing zones in some states, in Indonesia, in the Philippines, and Vietnam. Also, regulations on the limitation on the use of temporary agency work. No? This we found again in India, with some exemptions, in Indonesia, in Japan, the Philippines, South Korea, and Vietnam. And then the limitations on renewals, because in Cambodia, for example, they say maximum of 2 years, but can be renewed. So it drags. No? But then they had to make it explicit, in the prakas or the ministerial order or regulation, limitations on renewals or overall duration of fixed-term work, no? Because this is abused in terms of casual work and temporary agency work. Again, this is in Cambodia, Indonesia, you see the countries here, Japan, the Philippines, Singapore, and South Korea. And then this one is limiting non-standard employment to non-core activities. So whatever is the core business or activity of the company, that cannot be outsourced or that cannot be assigned. The jobs related to those core activities cannot be assigned to, non-standard employment or non-standard contracts. Again, in India, Indonesia, the Philippines, and Vietnam. Other regulatory changes, would be, which we see I will later on discuss. Of course, collective bargaining can also be an effective means, whether it is workplace-based or enterprise-based or industry-based. Better if it is higher level, no? Industry-based or national, no, bargaining. But in many countries in Asia, the dominant system of bargaining and unionization is at the enterprise level, not industry bargaining. It's not prevalent. No. So here you can see the ways in which collective bargaining can be strengthened in order to address non-standard employment. And I will give you concrete examples in specific countries later on. So I will not. It's just I will not discuss this one later, just to show you. Other policy measures. Again, you can also have policies in terms of extending social protection to non-standard workers. For example, you eliminate or lower the threshold regarding working hours so they can be eligible for coverage for Social Security, flexibility with regard to contributions, so it may be lower, and then there is some subsidy from the state, so many innovations later on, and then recently I think India passed, no, it's Social Security law.
Yes.
Yeah, which covers, for the first time, I think it's the first legislation that covers workers in the gig economy and the platform economy. So that's a very good piece of, although there are limitations, but yeah, it's a first step. And then portability of entitlements between different Social Security schemes, meaning I can transfer from one Social Security plan to another. You know, that's what it means. Or in terms of migrant workers, you know, when they go from one country to another, they can still have, you know, their Social Security contributions, for example, in ASEAN, be recognized or credited, and then they work in another country. And this is one of the engagements of trade unions at the ASEAN level, to have portability of Social Security coverage amongst the countries in the region, particularly the ASEAN region. But it's still not finalized, it's still out there. No? The engagements and the struggle for this one is still ongoing. Again, what is this? This is the same, no? Administrative procedures, misclassification of workers, and then of course complementing formal social insurance programs with non-contributory programs. Meaning the workers do not contribute, meaning perhaps they receive subsidies, no? Or some other, for example, a local government contributes to their Social Security coverage. That is also possible in some other countries. I have, so there are many regulatory frameworks, and of course you will get lost, no? So I tried to come up with a typology of all these existing regulatory frameworks in ASEAN and also in other Asian countries, and I think this is also applicable in other countries outside Asia. So here I have proposed two types of regulatory frameworks in response to non-standard employment. So I propose three typologies. The first one is prescriptive, the second one is system-based, and the third one is a relaxed regulatory framework. The dimensions are in the first column, as you can see. So the focus of the regulation is, of course, under prescriptive, you have prescribed actions. So the regulation of the law is very, very specific in terms of what is not permitted or what is permitted. So it's prescriptive. No? And then system-based would be process or system. The system-based meaning this can be a product of tripartite, negotiations between the social partners. So there is somehow, a semblance, or no, that's a semblance. Somehow, a dimension of, negotiations on equal footing between amongst the social partners, meaning trade unions, employers and their organizations, and the government. And then the relax would be, it's silent, it's not there, so anybody can do it. All systems go. All systems go, right? And then another dimension would be nature of rules and standards. As I said, particularistic, detailed, system-based, process-oriented, as I said earlier. And then the relaxed would be, it's vague, it's indefinite, so, you can violate anytime, okay? And the main form of regulation you see here for prescriptive, the labor law, labor regulations, issued by the Ministry of Labor, case law. In the system-based, of course, labor law and agreements in the tripartite negotiations. And this is very, very specific in Singapore, for example, where there is a very, very rich culture, historically, of partnership. Okay, we can debate on that between the social partners. And then the relaxed would just be the labor law. The main actor, so these are the dimensions. in the regulatory process, in the prescriptive, the government, the system-based, the so-called IR partners or the social partners, and the relaxed, the government. And these are the countries. Based on my analysis of their regulatory frameworks, I consider Cambodia, Indonesia, the Philippines, Thailand, and Vietnam as having prescriptive regulatory frameworks, but it doesn't mean that there are no violations. Right? Even if it's very specific, very normative, no? Detailed, still you have. That's why you have a high incidence, still. No? System-based would be Singapore, and then the relaxed one, would be Malaysia. What about South Korea?
I think system-based.
System-based?
I'm not sure.
Do you have like dialogue with the trade unions?
Yes, trade union and business sector and the government, but it does not work
Yeah,
well.
but you have to
Okay.
protest first, right?
Yeah.
Before the government gives you the orders, right?
yes.
Yeah. So I see that. Yeah. In India, what do you think?
I think it will be more towards prescriptive, but elements of system-based, because
Okay.
we have a tripartite system for figuring out all of the regulations and the processes, but our laws are very descriptive and lay down clear guidelines on what to do, what not to do, what is the different categories of work, which should not be the core and non-core work that we were discussing earlier.
Okay.
So that way I would say more prescriptive, but elements of system-based.
Okay. Belarus? In Belarus?
I think prescriptive.
Okay.
Is only prescriptive. I can't say that we have like system-based
Okay. Yes.
features.
Or relax. It may be prescriptive, but in terms of implementation, it's relaxed.
Yeah, right.
Yeah. In other countries?
I think it's Ghana.
Ghana, yes, Ghana.
Ghana is system-based.
System-based,
We have the tripartite, which meets every year to determine the minimum wage for.
Yeah.
I mean,
And do you also discuss like this temporary work and in the tripartite dialogues?
In the tripartite, we have the government and the employers association
Okay.
and the trade unions representatives. So
Yes.
in the employers association, most of them are the leaders from the industries, manufacturing companies, small and medium enterprises.
Mhm.
Leaders. Mostly this non-system employment is prevalent in these areas than the public sector.
Yes.
Yeah, so I think they are available. The only challenge is sometimes when it comes to the implementation,
Mm-hmm.
there is some element of relaxed.
Yeah.
Because the laws are there, but the implementation becomes a bit challenging.
Yes. Which is often the case in many countries. In your country?
My country is Brazil.
Mm-hmm.
I'm not sure if I understood what is prescriptive, even with my translator. But I believe my country is system-based.
Okay.
Even with, we have a huge number of people who is not standard.
Yeah,
We can
yes.
say totally. Nowadays in Brazil, probably 40% of the population are no employee or non-standard. Yeah, I love this term.
Mm.
Non-standard employee. Even, I don't know the numbers, but I will check.
Yeah.
Even the number of standard employers that we have, inside it, we probably gonna have non-standard situation.
Yes, that's correct.
Yeah.
Yeah,
so-
yeah, yeah.
Yeah, I think to add to that, it is now coming up, especially where I come from now, the informal sector is
Yes.
about 80%.
Yeah.
And so if the relaxed system is there where they take decisions for sort of the public and the
Mhm.
formalized system, then the rest of the employees are left behind.
Mm.
However, the social security system
Mm-hmm.
gives that right for every employee to contribute towards their retirement and what have you. But I think that there is more that needs to be done because of how now the new system of the informal sector and the precarity is even coming into the formal sector.
Okay, yes.
Yeah, I'm from Peru, and I'm pretty sure we have a prescriptive type of regulation there. Even though we still have a lot of precarity and our economy is based on informality work mostly.
Yep.
Yeah.
Yes?
I'm from Pakistan, and for LSCs there is only one segment which has gotten a law for their rights, and that is the home-based working women.
Okay.
Recently, our province passed a law in which the women who work in homes on the work that the companies outsource, that the
Yes.
garment industry outsource, that from this law they would be able to get social security, pension and leasing. But this is just one segment of LSC. For the other, I'm not even sure that it's even prescriptive, because
Yeah.
no one is like talking about that.
Okay, yeah, that's good. So it appears that even in other countries outside, the ASEAN, the prescriptive type, appears to be the dominant type. That's why at the first slide about the regulatory responses, I said it's tightening of regulations. That's why, and one way of tightening regulations is to make the regulation more prescriptive, more detailed, what is allowed, what is not allowed, what jobs can be outsourced or for agency work, what jobs can be not outsourced, etc. So this is what we mean by, like prescriptive. It tells you in very, very specific form or very detailed, the regulations, the limitations, and and where you can use, non-standard forms of employment.
Melisa, can I ask a question?
Yeah.
How fixed are these regulatory frameworks in terms of a country's development? So is there a path one can observe that you go from relaxed to prescriptive, so that you can set it in those frames? And how useful are these typologies, since they always fall, like when we were just discussing about it's a prescriptive framework with a relaxed implementation, for example. Is it then more useful to even break it down into smaller segments that we observe, rather than having the whole country's regulatory system at hand? So that's maybe a question. So is there a system that has ever been observed to shift from one to the other in a very rapid way? And is there, rapid, no, I guess, but has it been observed in the case studies that you've been looking into?
Yes. For example, you can go from prescriptive to system-based. If you have a strong culture or tradition of a social dialogue between the partners. And of course, if in those, for example, in Singapore, it's very, very strong. They have a tripartite structures for each, sector or each category of employment that can be, and then you don't need the law, because people tend to observe even, the agreements at the tripartite structures. So at any given point in time, even a relaxed one can be prescriptive. But of course, there are many factors involved, from the shift. And this is a gradual shift. You can't do this overnight unless you are being colonized or you have an authoritarian regime suddenly there, or a dictatorship. But I think the most important thing here is this. We should take into consideration that, these frameworks are not like the benevolent actions. Okay, never mind the relaxed, You have to have a strong trade union organization or workers' organization to push for example, a prescriptive regulatory framework if you want, or a system-based, meaning all the social partners are equally represented and have equal voice in terms of, influencing the kind of policy making or legislation that the country, issues in terms of addressing, the precarity associated with non-standard forms of employment. Yes.
I was thinking, because you were discussing about, for example, being prescriptive country, but in a system-based moment.
Yeah, that's possible.
Because I believe that because this last 10 years in the world, 10 years maybe, in the world, that we are facing a new race of the ultra-right presence. We have seen not only in Brazil but in different places. Like Brazil, for example, has the most advanced workers' law in the whole world, which doesn't mean that the law works, is applied all the time, even with also a very strong workers' movement. So I was wondering that how fixed those terms are, or if they are not, because they change, even if we have if we have the law, a prescriptive law, for example, in the system, if we can really face a relaxed action in terms of all of these. And
yes, I get your point. You may have a prescriptive framework at this point in time, but then you have, for example, a dictatorship or Bolsonaro scenario, for example, came, and it becomes relaxed, even if the law exists. That is possible in terms of implementation. What your points are correct, Alex, too. That you can have. These are periodic, For this period, for example, it was prescriptive, and the next time it became system-based, and then it became relaxed. So there is a continuum here. You cannot fix this forever that this is prescriptive, because these are institutions, policies that can be changed according to the power, of the groups of interest groups, in society. So if you have a strong, for example, trade union movement, you can influence the shift from one typology or from one type of framework to another. So I'm not saying that this will be the type of regulatory framework forever for each of these countries. It can change, it can shift. It can also be a rapid shift, When you have, for example, you elected in my country, it's an authoritarian, populist authoritarianism, We have prescriptive, regulatory framework, but still the trade unions, are struggling for more regulation, because having a framework is one thing, but the implementation of those existing laws is another thing. Yeah, which often that is the gap. Right, in many countries.
Melisa, I'm sorry, we had a question in the chat.
Okay.
So, what did you mean by relaxed from Sarina? Maybe she would like to. Sarina, would you like to explain your question, or shall we leave it for later?
Yeah, we can do it.
Yeah. Sarina, we don't hear you. I don't know.
Yeah.
Yeah. Go ahead, please.
From which country?
I'm from Indonesia.
Oh, okay. Yeah. Hi. So, should I answer her question?
Yeah, maybe.
How can I go back?
Sorry, I got lost.
Yeah. Yeah, but I have already discussed earlier the difference. Perhaps we can go back. When I say relaxed, you have a law that is vague and indefinite. You don't really know, okay, is it allowed or is it not allowed? So sometimes you have to challenge it. Sometimes you have to take a case to the court in order to determine, the intent of the law. Okay. And if you have rules, they may be vague and indefinite. And then, of course, if they're vague, it is open to multiple interpretations. So this is what we mean by a relaxed, particularly a relaxed a regulatory framework.
Yeah.
Okay?
A quick
Yeah.
question.
Yes.
We have the labor law at the system-based and also at the relaxed.
Yeah, but you may have a labor law, but it's vague or broad.
Yeah.
No? So that is why it is open to a lot of interpretations. Which is the case in Malaysia.
And in Ghana,
Very broad, how the law is articulated or expressed, or the language of the labor law in Malaysia is so broad. Yeah? Okay. So again, here again, I try to make like constraints just to show you, like, you can play with this. If you will do your thesis, you can also do something like this, no, high, low. So I try to compare in terms of high and low. Of course, it's very in terms of constraints or restrictions on the use of non-standard forms of employment, and then the explicit provisions or protective rules on the rights. Now this pertains to the rights of the non-standard workers. So you see here for the constraints, you have low and high. The explicit provisions in the law or regulation on protecting the rights of non-standard workers, again, low, high. So here, based on my analysis, I consider Malaysia low on both dimensions. I consider Cambodia and Singapore low, specific provisions on the rules pertaining to the protections accorded to non-standard workers. But they may be high on the restrictions on the use, no, this is different, on the use of non-standard employment by employers. Okay. And then Myanmar and Thailand, I consider them, they have explicit provisions on the rights of non-standard workers. It's high, but it's low in terms of the law saying, okay, what are the restrictions on the use of non-standard forms of employment? And then, of course, high for both Indonesia, Philippines, and Vietnam. But then again, a caveat, it doesn't mean that, it's again, you know, in terms of implementation, it doesn't mean that there are no violations of the regulatory frameworks on the use of non-standard employment. So that's another thing, okay? And I think this is my conclusion for the first part. So first, you see there are various categories of non-standard employment, not just in ASEAN, but in many parts of the world. So the governance response, meaning the government's response, is to tighten the regulations, often as a result, no, of struggles of trade unions, demands of trade unions, protest actions and mobilizations of trade unions, and of course also protective measures for workers in non-standard employment. The regulatory adjustments often follow a multifaceted approach, you know, like the regulatory gaps are plugged or, you know, addressed. Of course, you have to strengthen the representation, collective bargaining rights for workers, extension of social protection. So it's not just the labor law. You know. You also go to the social protection in terms of coverage of social security, pension, etc. And then, of course, also employment and social policies, you know, to manage, you know, the risk associated with non-standard employment, which, okay, I will show you in few examples in the second part of the session. And that's it. Okay, so we go to the trade union responses. Of course, trade unions are responding to the rise, you know, because it threatens their very existence. In many parts of the world, the trade unions are only organizing permanent workers or regular workers, but not non-standard workers. Not many unions do that. So let me give you some examples. Let's try quickly. Example. Okay. So I said earlier, one way to address, you know, the precarity associated with non-standard employment is to bring in workers on non-standard employment, to bring them in social security coverage. So here is a case study, which was part of our Trade Unions in Transformation Global Project with the Friedrich Ebert Stiftung. The trade unions in 2010 formed this action committee for social security reform, which is an alliance of unions, NGOs that push for universal social security system that of course also includes workers on non-standard employment or doing non-standard work. So that because of this initiative of the trade unions there in Indonesia, the parliament passed the law on social security providers, and then subsequently the social security law that extended coverage of social security to all Indonesian citizens, regardless of their employment category. So that's one. So these are one of the pictures of the mobilization. In Singapore, the Trade Union Center, National Trades Union Congress in Singapore, established within its organization what they call the Unit for Contract and Casual Workers. It's a separate structure in the trade union structure of the NTUC in Singapore. That would represent low-wage workers in the outsourcing business. So this is the systems approach in the typology, right? So they formed the tripartite cluster for cleaners. So this is for cleaners who are often in non-permanent contracts. In 2012, because they saw that the wages there are stagnating, in the cleaning industry, so they pushed for the adoption of what they call the progressive wage model, for these workers in the cleaning, security, and landscape. And then they initiated the adoption, of course, at the tripartite level, what they call the best sourcing initiative, to provide agencies or the service providers guidelines on best sourcing practices, including the rights of workers in these industries. And the outcome so far is that, they set the minimum salary for 3 low-wage sectors, and this benefited 70,000 workers in the sector, and they found that the real wage growth of the low-wage workers exceeded the median income between 2011 and 2016. There was also skills upgrading, so that's why they call it a progressive wage model, because they're being trained so that they can progress from cleaning, and then they go up the what we call the labor market in the sector. And then later on, when they found that this was successful, they extended it to the other sectors where non-standard forms of work are prevalent. This is not working. Sorry.
No, I'm sorry. It's about clicking.
In the Philippines, again, at the tripartite level, we have the initiative of the National Union of Bank Employees. At the tripartite level, because we have in the Philippines like sectoral tripartite councils, so the trade unions there were able to negotiate at the banking industry tripartite council some protections for jobs that are outsourced. So at that level, they were able to identify the functions of the bank that were limited to 5 areas, and then issue a regulation, which means the unions should be consulted for any plan of the company or the banks that involves outsourcing certain positions or reassigning affected workers to other departments and engaging third-party subcontractors or agencies, or dispatching companies. So they were able to negotiate that at the tripartite level, meaning at the sectoral or industry level, which is a form of bargaining. And then in the Philippines, this one will just show you, this was the findings of my research that I did between 2015 and 2016, involving 93 enterprise unions and 13 national federations. And here I found the variety or the bricolage of organizational forms that workers on non-standard employment organize themselves into, so they can organize into workers' association, or they can organize a union but only for non-standard workers, or sometimes they are part of the regular membership of the union, or you have a union and then they make a separate structure for non-standard workers, like what happened in Singapore, for example. And then or in the union executive board or executive committee, there is a representation of workers on non-standard employment, and then of course in the bargaining panel or in the bargaining committee. So these have been the variety of ways, and I found out that unions tend to decide to represent and accord protection to non-standard workers depending on these factors. The second column would be pertaining to the local unions. The third column would pertain to the national unions. So you can see the check, these are the factors that I think affected, the decision of unions to represent or to organize the workers, whether in a separate organization or to recruit them within their union organization. So if there is a legal framework that protects these workers and regulates the use of these forms of employment, if you have a more inclusive union orientation, for example, they're more inclusive, if there is a high unionization rate in the enterprise or in the sector, stricter enforcement of labor laws by the government, if there are already many non-standard workers in the union membership, So these are the factors, and all the rest influence, a union's decision to organize non-standard workers. So these are the ways, for example, in the Philippines and also in other countries, the trade unions accord protection to non-standard workers and at the same time regulate the use, particularly at the enterprise level and even at the national level, the use of non-standard employment. So at the national level, they push for laws, and this happened in many countries, in Indonesia, in South Korea, in the Philippines, in Brazil, in many other countries. They campaign, they mobilize against contractualization, meaning, you render an employment short-term or fixed-term. You make representation in the Labor Department, of course, dialogue with employers on the use of non-standard employment, and then you can even have union to union, whether within the country or outside the country, coordinating for some actions in terms of restricting the use of non-standard employment. That's what it means in the supply chain, for example. International support, particularly of the global union federations and the ITUs in the campaigns. And as you have seen in the case of the Social Security coverage in Indonesia, having coalitions, developing coalitions with other unions, NGOs, in mobilizing for protection and regulation of protection of non-standard workers and regulation of the use of non-standard work. So here you can just see how collective bargaining regulates the use of non-standard employment and accords protection to non-standard workers. This was from another study I did, again focusing in the Philippines. You can have these provisions. You can negotiate these provisions in the collective agreement, actually. So there are many ways to do this. And I found out that if these provisions in the CBA, having these provisions in the CBA are more likely when the union organizes or recruits non-standard workers. Yeah. So in conclusion, in terms of trade union responses, I see that the trade unions have a dual strategy. And they combine these two strategies. Representation in terms of organizing workers in various forms, not just trade unions, and regulation. Whether the union organizes these workers or not, they try to fight for the regulation on the use of non-standard forms of work. But again, the strategy of regulating employers' use of non-standard employment appears to be the dominant strategy. Nonetheless, there is still incipience, like infant stage, that's what it means, of union representation of non-standard workers. There's a bricolage or various forms of organizations used by unions to represent non-standard workers. Unions can regulate the use of non-standard employment either directly through collective bargaining, dialogue with management, or a special agreement at the enterprise level, or indirect. And the indirect even covers broader, workers through legislative initiatives, government, tightening of regulations at the national level. What is very, very distinct from all these researches is there is a plurality of innovative union strategies to represent and protect non-standard workers and arrest, not the employers, but the spread of non-standard employment. So it does not work again, yeah, so I think,
but I'll tell you later.
so some unions, they undertake some renewal or transformation as part of, and organizing non-standard workers is part of this renewal process, and you can read these things later on, so I don't want to get into detail. This is the exercise that I was thinking, but you can do this on your own, later on. Okay, so it ends there. This was the mobilization in the Philippines, an ending contractualization, which is, making permanent work non-permanent. Minimum wage of is so 750. It's just over 10 euros, I think, that one. And these are the next slide, please. So I'm ending it just to show you. These are the references, and many are available in the internet.